first case today is in adoption of BC. We've allocated 20 minutes to a side, but if we're still asking questions, please continue to respond. It won't cut into any rebuttal time. Justice Nielsen will be joining us virtually today. Okay, with that, let's begin.
Good morning, Your Honors. Emily Adams for the appellant CC.
Welcome, Ms. Adams.
Parental rights can be terminated only when truly necessary, not simply because it seems fairer for a step-parent to step into a parent's shoes. When asked during the termination in this hearing, in this case, why mother thought that termination was necessary, this is what she said. I feel like it's unfair for a man who has raised the children from such a young age to not have the same rights as a biological parent. I don't think it's fair for the children to be expected to have an individual that has been missing in their life for 10 years and expecting them to have a relationship with this individual that had done very little to have a relationship with them, whether that was by choice or whether he was told he couldn't do it. It's not fair. That's on pages 385 to 386 of the record. Fairness to a step-parent is simply not enough to terminate parental rights, but that's exactly what happened here. The district court in this case gave three reasons for why it was strictly necessary to terminate father's parental rights, but all of those are wrong. The first ground was because of guardianship. The court was concerned that if mother died, then stepfather would have no legal rights to the children, and there could be a messy legal dispute between father and stepfather. But there was absolutely no evidence in the record, and there was no finding from the district court that mother had any health concerns or that there were any worries that she could die in the future, imminent death. Now, the children here, from what I understand, are ages, I think, about 17 to 9. This was a categorical concern. In any type of case where you have a step-parent and a biological parent, if one natural parent dies, there's going to be some kind of concern between the step-parent and the natural parent about who has custody. But there were no specific findings in this case that tied that concern to the specific children in the specific instance here. It was simply a categorical concern that cannot support termination of parental rights. The second reason...
Can I jump in on that real quick? I mean, I understand what you're saying about the categorical concern, but can't the concern be more nuanced in the sense that if something did happen to her, and something could happen to any one of us on any given day, right, that this would be so disruptive to them to all of a sudden have to deal with this situation where the person that has raised them is no longer able to assert any kind of legal right to them. And that's the concern. And it's not so much categorical in the sense that can be true for any child. It's true about these children in particular who need the stability and continuity and need the same upbringing they've been having for many years. So does that make it not categorical then if we're talking about what these kids could specifically experience should an event like that happen?
It would not be categorical in that context, Your Honor, if there were more findings to that regard. I mean, the court just said in the case of guardianship, for example, the termination of the guardianship would give rise to future litigation regarding the reinstitution of these parental rights. If it were to happen, it would be problematic. So the court doesn't really go into specific findings about these particular children in this particular case. Well, it feels more categorical.
Okay, but I mean, he does say in, I think, paragraph 38, that there's a significant susceptibility to unstable or unprotected or unpredictable environments, and because of their diagnoses. And so why doesn't that then feed into and support that finding?
Well, we also have some speculation that if mother were to die, there would be some sort of big legal dispute between stepfather and father. There weren't any findings in this case that father was opposed to stepfather or that father wanted to step in and completely take over for stepfather. If we had those kind of connections, this might be a different case. But we've got a lot of speculation about what could happen in the future without any evidentiary basis.
Okay, help me just from a legal perspective then understand. So let's say mother passed away tomorrow. what would happen? Would father be, or would stepfather have any standing to come assert rights to these children?
From what I understand, Your Honor, there could be stepfather could initiate some sort of guardianship proceedings. However, it is an uphill battle from what I understand. Generally, natural parents have precedent when you have guardianship proceedings. So there is a legal path for stepfather to assert those rights. But of course, there were no findings in this record that father would do anything to disrupt the current situation. Father is very aware of the children's situation, is very aware that stepfather has been a significant part of these children's lives for the last 10 years. And there were no findings that he was willing or would have disrupted that.
Okay.
Getting to their disabilities, the court was concerned that 3 of the children had disabilities that made them sensitive to instability or unpredictability. 2 of the children are on the autism spectrum and have ADHD, and then the oldest child has an intellectual disability. But the court made no findings that allowing father to continue in the children's lives would bring instability or unpredictability, and that's the problem here. There is no link between father's ability to remain in the children's lives and creating instability and unpredictability. And what's really fascinating is when you look at this record, the evidence that was presented, these children can handle some instability and some unpredictability. For example, on page 476 of the record, stepfather testified that third parties come in the home to work with the kids. And on page 478 of the record, stepfather testified that mother brings home a special needs adult on the weekend to stay with the family. So it doesn't seem to be a situation where the children need to have the exact same thing all of the time. I think that certainly with some children that have autism, you need that. But here, the youngest 2 children, DC, who's 12 years old, he's out of therapy. He's doing well. He says his autism affects his ability to understand social cues. And then the youngest, BC, he has ADHD and autism, but he's very social, and his ADHD is more inattentive. And they talked about, mother testified how he has some problems with impulsivity, but his impulsivity is crossing the street without looking and riding a scooter down a slide. That's 369. So this isn't something that we're talking about extreme circumstances.
What about the facts in the record that talk about how mother testified that when they would go to spend time with father's family, they would come back and they would regress? They would be more argumentative. When they had an introduction of different set of rules, it would affect them. They were susceptible and would cause a tailspin. Why aren't those kind of facts sufficient to support the district court's finding here?
So that's really important. So that's on page 383 of the record. And I think it's really important what the testimony actually says. And what mother testified to there is that when children would go for a sleepover at aunt's house, they would come home and they would call stepfather by his first name rather than dad. And the third child would have a harder time following the rules. And then they asked, was there some correlation between that change in behavior and contact with Curtis? And mother said, it's an assumption, I don't have any proof, it's just kind of an observation. And counsel asked, so the kids didn't come back and tell you they talked with Curtis? And mother said, correct. And then counsel clarified, so you said that the children kind of grew into this relationship with his stepfather? And the mother said, correct. So essentially, at the very beginning of their relationship, it seemed like stepfather had a harder relationship, especially with the younger 2. And the relationship has grown and developed over time. Children would go to sleepovers at aunt's house, and they would come back and feel a little grumpy. Whenever kids come back from sleepovers, they feel grumpy. They had stayed up way too late. There just is not enough evidence on this record to connect that father's influence was disrupted. There was no evidence that father talked with the children during these sleepovers. And what's really important on page, on page 382 of the record, mother said that she'd asked aunt clear back in 2015 to not act as a bridge between the kids and dad, to not have calls or anything. And aunt respected that. And the one time that was broken was in the Christmas of 2022. And aunt immediately, she said she testified that she felt uncomfortable. The only reason she picked up the phone was because dad was calling and calling and calling. So she picked up the phone, the kids stopped quickly, and then she told mother about it right afterwards. So it's not like these kids were having any interaction with dad. during those sleepovers. So that's a very long answer to your question, Your Honor, that the testimony doesn't establish the kids can't handle any kind of disruption. It just seems like from the testimony about the sleepover at the aunt's house, it was simply children being grumpy after a sleepover, which is really, really common. There's nothing specific to these children generally, and there was nothing tied to being involved with Dad. And it's not clear that if Dad were to be involved in these children's lives, that they would be allowed to sleep over with him, at his home. It might be start with just contact, and Dad was asking for therapeutic reunification. Let's start slowly. Let's start with therapists. Let's be really careful about how I can connect with these children again.
I just wanted to clarify some of the facts about whether Father was allowed to have contact with the children while he was incarcerated. So it wasn't entirely clear to me if there was a term of his sentence that disallowed contact with the children, because it seemed like some of the facts were that in the beginning of him serving his sentence that the children would visit him, that Mother would bring the children to visit him. But then in other places, there was just a quick reference to couldn't have contact with them because of the terms of the sentence.
Yes.
So I was a little confused about that.
Yes, it is pretty confusing in the record. So Father was arrested in July of 2013, and from what I understand from the record, it took 2 years for him to be convicted and sentenced. During the pendency of those 2 years, that's when for the first, I believe, 6 months or so, well, from July to October of 2013, Mother was driving the children once a week to the jail to see him. And then from October 2013 to 2015, a mother and children were having phone contact with Father. So this was all during the pendency of the criminal case, and it didn't seem like there were any restrictions on his ability to contact the children. And then once he was sentenced in 2015, this is on page 466 to 467 of the record, as part of his sentence, he was prohibited from contacting children. He admitted...
So children in general?
From what it seems, it was all children, yes.
All children, so then that includes his own children.
Yes, and so Mother found out about this term, and she testified that even though, I think she found out about this term later on after the sentencing, it was in 2015, but it was sometime after the sentencing, and she testified that if the court thought that he shouldn't have contact with the children, then why should I allow contact with the children? So that's when she cut off everything. Father did send letters in 16 or 17, and he admitted at trial that he was breaking that, he's basically violating the terms of his sentencing by sending those letters. 2 years before he was released, he was put into the sex offender treatment program. And once he was finished with that treatment, then he was allowed to contact the children again, and that's when his probation officer contacted Mother and asked if there could be a phone call, and Mother said no. So the answer to the shorter answer to that is for the first 2 years he could contact. From 2015 until 2022-ish, he couldn't under the terms of his sentence, and he testified that after he completed his sex offender treatment program, he went back to court and had his sentence modified, the terms of his probation modified so that he could contact his own children.
So I guess that those facts are relevant to a couple of things. One is when you're not allowed to contact your children, how does that factor into the determination about whether you've abandoned your children? And when it was an involuntary abandonment, or the contact was stopped not because he just took off and decided he didn't want to contact his children, but because of a court ruling. So how does that weigh into that? And then the other thing I couldn't quite tell from the findings, there was some testimony about whether the father is a danger to his children. He has this conviction on his record for abuse of a minor, and but it didn't seem to weigh into the court's decision that much. So I'm just wondering about the status of that. So I guess number one, in terms of abandonment and making only token efforts, what's the legal relevance of the fact that that was disallowed by court order? And his safety around the children.
So the courts that have dealt with this in the past, especially the Court of Appeals, have determined that when you have a parent who is prohibited from talking to their children through some sort of court order or something, they generally don't count that against the parent when it comes to abandonment or token efforts, or at least it's part of the consideration with abandonment and token efforts. Of course, we're not challenging abandonment and token efforts here. We believe, of course, that the evidence supporting the grounds is pretty slim, but because you only need one ground to terminate parental rights, we focused all of our energies on the best interest prong.
Can I just ask one point of clarification? I thought that being incarcerated for more than 1 year was a ground.
It is, so that's one reason why we are not
Oh, I
challenging
see.
grounds.
Okay,
Yes, yes. We think that the evidence for, the court gave 4 grounds, and we think the evidence is not strong for 3 of those 4 grounds, but if you have at least 1 ground, it's enough, so that's why we didn't challenge grounds. And then as for the sexual abuse, Your Honor, the evidence was that there was a 15-year-old troubled teen that was staying in their home and that some sexual interactions occurred between the father and this 15-year-old. And he pled guilty to, I believe, 2 counts of sexual abuse of a minor. Mother testified that she was asked directly, and she testified that she did not believe that father was a danger to the children. Even though there was, although she said, it's something that's on my mind, but is he going to sexually abuse his children? I don't think so. Moving on just briefly to this last ground, the last reason, the court said that, was concerned that because the children need stability and permanence, the court should enhance their current relationship between stepfather and make it permanent, but there was no evidence that the children's lives would materially change at all if father remained in their life, and if stepfather continued to be their stepfather as he is right now. Mother has full legal and physical custody of the children in her divorce decree, and there was absolutely no indication in the record that father was going to do anything to push back against that or to get that changed, and he probably couldn't, given his circumstances. There was no evidence in the record that any visitation would be harmful or would disrupt the children or their feelings of permanence. And it's important that the children visited father and called father for the first 2 years after he was incarcerated. It wasn't until 2015 when mother met stepfather and then found out about this sentencing condition that all contact was cut off.
I recall somewhere that it said the youngest has never met the father. Is that true still?
Yes, so the youngest was born after he was incarcerated.
And still has never met him?
No, Your Honor.
Counsel, assume for a minute that the guardianship would be disruptive to some degree. I understand your primary argument to be that notwithstanding, there's no evidence that father's presence as a guardian would cause that disruption. What would you expect of the court in this regard? What kind of evidence might have satisfied this causal connection?
We would need some sort of evidence that father was perhaps intending to come in and assert rights to disrupt the family. We would need some kind of evidence that the children would be affected or harmed by father's involvement in their life. In In Re DS and In Re AH, there was direct evidence that the children were harmed or traumatized by the biological parents' contact with them. I believe that was In Re DS. And in Re AH, there was testimony that the children were really closely bonded with their foster family, and that disrupting that bond at all by having them go back or have any kind of relationship with their natural family would cause trauma and it would create problems with bonding, permanent problems with their bonding. We don't have any evidence of that here, Your Honor. We're quite different from DS and In Re AH, considering that the children here did have an interaction with father. In fact, he was quite involved in their lives until the oldest child turned 6, and then for 2 years they were in contact with him, and it wasn't until 2015 when things stopped. We just don't have any evidence that father still remaining a part of their lives would be harmful to them, causes them any anxiety, causes them discomfort. There's just no testimony about that at all, and we would need something like that here for the court to decide that termination truly was strictly necessary.
Why doesn't the tailspin testimony cover that?
Sorry, that's a voice from the top, Justice Nielsen. Ooh, sorry, I apologize.
I said, why doesn't the tailspin testimony cover that? That the kids went into a tailspin when they contacted their dad?
So the tailspin testimony, what was all speculative, right? It was just mom was concerned about that could happen in the future. The only evidence we had we didn't have any evidence of children having any problems when they were contacting dad back between 2013 and 2015, when they had those weekly visits and those phone calls with dad. And then the only evidence we have of them having any problems is when they would go visit aunt during those sleepovers. And like I said, there wasn't any evidence that they actually talked with dad during those sleepovers or had any problems. And notably, the evidence on the record was that children have been having like a community-based activity with aunt once a month for the last 10 years. And there's really been no problems. So the evidence that mother was concerned about a potential tailspin puts us also into speculation ground because there's just no evidence on which that is based.
Can I ask you a quick, Justice Nielsen, did you have any follow-up to that?
No, thank you.
Okay. I had a question about the strictly necessary.
I have one quick question about harm first, just one last one. I don't know that we've ever said in the case law you have to show harm, affirmative harm, and that's the phrase you were using in the brief, that I was looking for that in the case law, I couldn't see it. And the fact that in other cases there is affirmative harm doesn't mean that that's necessarily a requirement, right? And I was imagining a case, for example, a hypothetical, where say there was a parent who just had completely not been present for a child's entire life, just had left it right after birth, so abandonment was clearly there. And then there was an effort to, they ended up living with a stepdad situation, someone who raised them for 15 years, right? The only dad they ever knew. And then they came to the court and said, look, we want to terminate rights. The parent appears and says, I promise, I just want to see you once a year. I'm going to have no contact with you. I don't want my rights terminated, but I promise I really won't interfere with your life. But the evidence is that for this child to be adopted by this parent that's raised them, to just have that be considered their legal father is very important to them, and they feel very strongly about that. But if we were to say, no, you have to show harm, I suppose in that case we would say, can't terminate the parental right, even though we have a parent here who really has next to zero interest in being in this person's life. So I guess I'm just wondering, in that hypothetical, would you be coming in here and saying, unless you can show me affirmative harm to them by this once a year visit or once a year note that the father's going to send, you can't terminate the rights, even though everyone would agree it would be in the best interest of this child to have those rights terminated? It's where I start to feel like the strictly necessary starts looking a lot like we're looking from the parent's perspective again.
Right, Your Honor. I think we would just need to rely back. I think maybe harm is too big, too strong of a word in that context. I think we would just need to go back to the language in BTB, where this court has said we need to look at whether other feasible options exist that could address the specific problems or issues facing the family, short of imposing the ultimate remedy of terminating the parent's rights. And so I think we just need to apply that language. Like, are there other feasible options that could, like, what in this case could be done to address the problems facing this family? And in a case where you have a completely absentee parent for over a decade, 2 decades, I guess it wouldn't make sense 2 decades because then they'd be an adult. But then perhaps it might be strictly necessary in that context.
But in that case, wouldn't you come in and say, well, there's a feasible option? It's to allow things to continue in the status quo, and that won't cause harm. And I feel like that's the argument that's being made to me today. And I'm just trying to figure out how I frame the loss, because that just seems to me like a strange result in the case that I've described to you. That where there's just, the parent wants to have so little involvement that no one could argue that it would be harmful.
I think that the tricky part, Your Honor, is that when we're looking at if what they're asking doesn't change the status quo at all, then it really isn't strictly necessary. And I think that perhaps is maybe a better way than looking at it through the lens of harm. If terminating I apologize, I'm a little bumbly this morning. If the situation in the family is not going to really change at all if the parent's rights are terminated, then why are we terminating parental rights? If the status quo is going to stay the same, then it doesn't seem strictly necessary for anyone to terminate parental rights. Now, Your Honor,
So in my hypothetical, then you would say no termination.
I would say that it's a close call because the status quo is not going to change.
Even though it's in the best interest of the child.
Well, if it's truly in the best interest of the child, strictly necessary in the best interest of the child, then yes. But I think when we look at it, I think we've got some case law that says that when things remain the same, if the family looks the same before termination and after termination, then do we really need to be
What if, okay, so what if those are in conflict? It's in the best interest of the child wants to be adopted, they care deeply about this is the person that's raised them, they want to be legally attached to them. Everyone says this would be good for them, but it really won't change anything if you just keep status quo, when those two things are in conflict.
And I think the statute does say that everything needs to be from the child's point of view. So I think we would need to terminate in that context. I'll say, Your Honor, that there are adult adoptions. So in a lot of ways, these children can move their feet at 18 and say, hey, I really want to be adopted by this person. So putting off the termination while they are minors, which can never be reversed, termination of parental rights can't be reversed, and allowing them to make that decision when they're a bit more able to consider the consequences of it, I think is pretty important.
Okay, thank you.
Justice Peterson.
I just wanted to talk about the statute for a bit. So the language in the Adoption Act is pretty broad. You can terminate an individual's parental rights if the individual's parental rights are terminated on grounds described in Title 80, Chapter 4, which I think is interesting because it's talking about the whole chapter. It doesn't specifically mention the subsection or a section that only talks about grounds, but then it does say grounds in the language of the statute. What I'm wondering about is it does seem like adoption proceedings, they proceed differently than termination proceedings in the juvenile court, especially if it's based on a child welfare proceeding. In an adoption proceeding, you may often have a voluntary relinquishment of parental rights or a default of one of the parents. And I don't recall ever, when I was in the district court, having to make a separate strictly necessary finding when there was a voluntary relinquishment, or now I'm realizing I think I may have been before the strictly necessary language, but so maybe it was too long ago.
It came in 2012, right?
Okay.
So you did everything perfectly the entire time you were on.
Thank you. Let's just say that. But I don't know if the practice in the district court right now is that they're making those strictly necessary findings when there's not a contested adoption. And so I'm just wondering, what to do with the language of this statute where the Adoption Act is just talking about Chapter 4 in its entirety, and how much might that sweep in that's peculiar to termination cases in the juvenile court, and how does that help us determine whether we should apply strictly necessary in adoption proceedings?
So let me address that in multiple ways. So first, let's talk about the voluntary relinquishment, and then we'll go to what does grounds mean. So Your Honor is right that we have a voluntary relinquishment in the Adoption Act, and we have a voluntary relinquishment in the Termination Act. The voluntary relinquishment in the Adoption Act does not require any best interest finding, whereas if you do a voluntary relinquishment under the Termination Act, you do have to have a best interest finding. I think the difference there is purely forum. So in the Adoption Act, somebody is terminated. The only reason you can terminate a parent's rights in the Adoption Act is if you have a parent who is willing to step in the shoes of the parents whose rights are being terminated. Right. If that parent doesn't exist, you cannot go forward. And so that means a parent is saying, yes, I'm voluntarily relinquishing my rights for the adoption by this person, and I think it's going to be great. In the Termination Act, we have a different circumstance where we have parents that show up in court and say, I want to terminate my parental rights to this child for the purposes of not paying child support. And so there actually is a provision in the Termination Act that says when we have voluntary relinquishments, we have to make sure that the parent is not voluntarily relinquishing because they want to remove their obligation to pay child support. And so I think that's why we have this additional, it's kind of a redundant best interests in the Termination Act because the legislature does not want parents going into court and just being like, giving up my kid, don't want to pay child support anymore. They want to make sure that children are entitled to child support until they turn 18, and parents shouldn't be able to get out of that obligation through a voluntary relinquishment. So that's the difference between the voluntary relinquishments. In the Adoption Act, where we have a parent who's willing to step in that parent's shoes, the child isn't going to be without support. But in the Termination Act, the child will be without support. And so that's why we have that kind of redundant best interest finding. When it comes to what does grounds mean, I think it's helpful to look at this Navarez v. MLS. It's 2015 Utah 34, and it was when this court was talking about actually the Adoption Act. And what was the Adoption Act incorporating? It was incorporating laws of another state. And what the Adoption Act said is that a parent, a father, needs to fully comply with the requirements to establish parental rights. And in that case, under Colorado law, there were just very, very basic requirements to establish parental rights. There were other options for establishing parental rights, but they were very basic requirements. And this court looked at the word requirements in the Adoption Act and said, okay, we are incorporating the requirements of Colorado law, but not all the options of Colorado law. So if father in this case has done the basic requirements to establish parental rights under Colorado law, that is what the Adoption Act is incorporating into Utah law. The Adoption Act is not incorporating the whole of Colorado law and all the options father could have done to establish parental rights into Utah law. So when we think about this, grounds, when it references grounds, there's only one grounds statute, and we've cited it in our brief. And the subsection 1 of the grounds statute has that very large modifying beginning that talks about strictly necessary in the best interests, and then it lists many circumstances under which the rights can be terminated. That is all grounds. That is what is incorporated into the statute when the statute says grounds, and then anything else that comes with it. Notably, the Court of Appeals addressed this back in 2007 in In Re TH, and we've cited that in our briefs. And in that case, notably that was before strictly necessary was added to the statute. But in that case, the step-parent, a stepfather came to court, and he had filed a petition to adopt a child and then sought to terminate father's rights under the Termination Act. And stepfather specifically argued that the framework for determining whether the parent-child relationship should be terminated varies depending on whether you're in the Adoption Act or the Termination Act. And if you are terminating through the Adoption Act, you don't have to show best interests. And the Court of Appeals said absolutely not. It says, we must assume even in the adoption context before a district court, the legislature intended that all relevant provisions of the act would apply when determining whether termination of parental rights is appropriate. And it said that in the Termination Act, you have to show best interests and you have to show grounds. And so those things are going to be applied when those things are going to be incorporated into the Adoption Act. Notably, stepfather here has not challenged In Re TH. I think there's a very good argument that when the Adoption Act was amended in 2012 to include that language for reasonable efforts, that the legislature was merely codifying what the Court of Appeals had done a couple years earlier.
Except the legislature added in best interests. So
Not
if
in
it did,
2012. It added in 2012 for the Adoption Act. So for 2012, in the Termination Act, all they did was add the phrase strictly necessary. And then.
but in the Adoption Act in 2012, they added best interests, right?
But the Adoption Act in 2012, they added best interests. But what's interesting is that the strictly necessary requirement was not tied to best interests until 2018.
No, I see that point. I'm just saying if the legislature really thought that it was just following what the Court of Appeals had done, it would have found it unnecessary to add best interests into the Adoption Act. Because it would have said it's capturing everything that's in the Termination Act.
Oh, Your Honor, I see it differently. I think
Okay.
I think that the court was just, I think it's hard to read tea leaves, whatever you do with the legislature, right?
Agreed.
But I think there's a very plausible argument here that somebody in the legislature read in Ray TH and just wanted it to be very, very clear from the plain language of the statute itself that it was grounds and best interests, right? That you have to show both.
And I mean, I just think it's hard to read the tea leaves because I think you
Yes.
could also then say, well, then, if you also want a strictly necessary in the Adoption Act, why didn't you make that absolutely clear?
Yes.
And have that still come by implication
Yes.
while you put best interests in expressly?
It is very hard to read the tea leaves here, Your Honor. But I do think it's very telling that we had this Court of Appeals case a few years earlier that said you have to do both. And then we see you have to do this two-part analytical framework that's been consistent in the Termination Act context for decades. And then we see the legislature going in and making sure that that two-part analytical framework shows up in the Adoption Act.
It seems like we have kind of the same problem that Justice Pullman was addressing in the grounds statute, because it refers to section 84-104, which includes both best interests and strictly necessary, but then it calls out strictly necessary specifically.
Yeah, so
I don't know what to do with that. The Adoption Act calls out best interests specifically, and the grounds calls out strictly necessary specifically, and really all of those are incorporated into the grounds statute through that reference to 104.
yes, so that is what our argument is that when the, well, I mean, in the ground statute itself, it actually says strictly necessary to promote the child's best interests. So in that huge beginning part, it does mention best interests and then lists all those grounds. So it seems like there seems to be a disconnect between the way that we have analytically framed how to work this statute and how the statute is written. So when we look at just the ground statute, 84-4-301 sub 1. Sub 1 is just massive, and it has that whole big phrase that talks about strictly necessary to promote the child, from the child's point of view, is strictly necessary to promote the child's best interests. And then it lists all the circumstances. This court, for the last several decades, has interpreted the Termination Act as needing a two-step process, first grounds, then best interests. But when we look at the statute itself, it's just kind of all jumbled together in one big thing. And so when the legislature is referencing grounds under the Termination Act, it makes sense that it is referencing that one big thing that includes both best interests and the circumstances under which you can terminate.
Even though the legislature's known that for decades, we've also referred to grounds as those specific things that the parent, abandonment, neglect, those things,
Yes.
right? So, I mean, they'd be using the term differently than it's been used in the case law.
They'd be using the term a little bit differently, but they also, like Justice Peterson said, they're not like accepting out this huge modifier in sub 1, and they're not saying just these subsections. They're just incorporating this entire act.
It would have been easier just to incorporate the act, right, as provided in the act, as opposed to the grounds described in the act. That would have been a clearer way to do that, at least, right?
Or even just all of that subsection.
I mean, there's a lot of easier ways that could have been, the
Right.
legislature could have handled here. But it is fascinating, Your Honors, that we talk about grounds and strictly necessary as two different grounds and best interests as two analytically different things. But in the statute, they're not. They're all combined together in one. And so when the when the legislature is saying grounds described, it makes the most sense to just incorporate this entire subsection. I know that the next argument in Cracked, we're going to be talking extensively about it, so I don't know if you would like me to continue or we can pause for now. All right, thank you, Your Honors.
Hey, thank you, Ms. Adams. Mr. Alston.
Morning, Mr. Chief Justice and Justices of the Supreme Court. May it please the Court, and I think fortunately based on the questioning that I heard Ms. Adams undergo, I don't think this case requires the Court to definitively decide whether strictly necessary applies in this specific case. Or it doesn't need to decide if it applies in every private adoption case. Right? In this situation, the district court went ahead and heard father's argument about it and addressed it, applied it to the facts, made child-specific findings that the district court determined satisfied that requirement on the record. So the question really before the court in this case is a much narrower one. The question is whether the district court clearly erred in determining that no lesser alternative could adequately protect these children's welfare.
Let me ask you this question.
Sure.
We have case law that says that strictly necessary can't be categorical in the sense that it can't be, well, termination and adoption is always a more permanent option.
Right.
Do you think that that reasoning applies in a case like this where you have a stepfather who has raised the children and the court finds that it's necessary for stability to have that stepfather have legal rights to that child? Do you think that's a categorical concern because it would apply in any case with these kinds of facts because we have a stepfather who raised the children, or do you think that that's more of a case-specific finding?
In this particular instance, and again, this is the only case that I'm dealing with.
Mm-hmm.
In this particular case, the district court made those specific findings relative specifically to these children. I don't think that the district court was saying or was trying to say, hey, in any case where we've got a stepfather looking for adoption, that need for permanence automatically trumps and satisfies the statute. The district court judge went through specifically and talked about the special needs of these children and how because of that they had this heightened sensitivity to that need, or that heightened sensitivity to stability and a greater need for that permanence. And because of that, in this circumstance, that need made that the guardianship or some less restrictive alternative, it wouldn't work. It wasn't in the children's best interest. I think it's sorry.
Yeah, and let's assume
Okay.
that all that is true, that these children are especially susceptible to disruption, to change. What is your evidence that awarding father a guardianship would lead to disruption and instability?
And I think that Justice Pullman was asking some questions along this line about what evidence there was that father was going to do anything in this particular case that would unsettle this sense of stability. I see the fact that this isn't a case where he said, stepfather's been involved and I'm going to agree with his adoption. My client pointed out to me this morning, this has been 6 years now since they filed this adoption action, that they've been litigating this, gone all the way through trial, and now been dealing through this appeals process. So I don't think it's unreasonable for the court at the conclusion of a termination of parental rights hearing to say, well, it doesn't seem like father is just going to sit back and do nothing, because while he did that for approximately 10 years, now he's not. And so it seemed like a very large red flag, and from the court's perspective saw that this isn't a case where father is just going to quietly.
The mere fact that he's contesting
Suggests
is
that
indicative.
that
So
need
that
for
seems like it
stability.
would be categorical. You'd have that circumstance
And
basically always in these circumstances. But I still haven't heard evidence about the causal link. What evidence in the record indicated? I'm not saying that he would do nothing, and he may well do some things. Just any evidence that what he would do or not do would be disruptive in the way that concerns the court about these children.
So the testimony was, and I think went through 3 of the 4 children, right? The oldest daughter and then the 2 younger sons talked about, testimony was very specific about their need for consistent structure, especially the younger 2 boys, and how that changes were very disruptive to them. And of course, this would be a very significant change for the father that they have practically never known or had any relationship with to suddenly come back into their lives. I don't think that's a categorical harm. I don't think that's a speculative harm. I mean, that these children have been, they've known one family structure, especially the 2 younger boys. They've known this one family structure for the duration of their lives, and disrupting that in any way, shape, or form, given, right, their need for structure and consistency, based on the testimony that mother provided about their conditions, the court determined that was sufficient to say, yeah, that would be a significant harm for these particular children.
Can you tell me what would happen if something happened to the mother tomorrow? If the mother were to die tomorrow, what exactly would happen to the children? What would be the process?
Well, I mean, I think the immediate process would be stepfather would continue to care for them.
Sure.
He would have to go try and seek out some sort of legal rights. I agree with, I think Ms. Adams indicated that then there would be there would still be contested proceedings as stepfather tried to establish some kind of rights, and father tried to say, well, I'm the natural father and so I should be involved there. So it would be another lengthy litigation process. And at this point, I mean, the oldest daughter now is over the age of 18. The second daughter will be 18 in September this year. And then the 2 boys, I think, I don't remember how old the youngest is. I mean, he's probably 12. And then the middle one is 14. So, I mean, another lengthy litigation process like this, and their years of minority will be all but over. But I mean, that's going to be it's a very fact intense determination, and given the track that this litigation has gone on, potentially something that would be quite protracted.
But could the father, I'm just trying to figure out how this works. Could the biological father ask for custody immediately?
I think he could ask for it. I don't know that the court would give it to him.
Sure.
But
Under these
certainly.
circumstances? Okay.
I mean, what would happen then is you'd have a biological father. The problem is it would put the kids in a really tough spot, because you have the biological father who hasn't had any involvement with them for now 13 years, and you've got the stepfather who's been the only father that they've known, who doesn't have the legal ability to make decisions, to do any of the things. He doesn't have any of those necessary legal rights. Any ability for him to be involved or to do things with the children is tied into mom's right as the other biological parent. And so the children would end up being left in this place of, well, what do we do?
Right, and that's what I was wondering. I mean, if the mom were to pass away, what rights does the stepfather have to even continue acting as a step-parent? Would he have to be appointed as a guardian?
Yeah, he'd have to go through a
Okay.
legal process to establish some sort of right in that regard.
Okay.
And that would be I agree that that's a challenging road to walk, given the state of the law.
It does seem that perhaps this is a problem you'd have anytime you had a step-parent adoption and a guardianship with the biological parent, right? That the other biological parent in the marriage might die.
Right.
And it certainly could be argued that it's categorical in that sense.
Well, and I would say that's part of the reason why, when you look at the adoption statute, it talks about the purpose of that being to help establish permanence for the children, which is exactly what mother is trying to do in this case for the children, is establish that permanence so that that very situation doesn't arise, and so that they have that stability and that ongoing continuity of care.
This may be a naive question, but is there anything that would preclude father from being named as guardian now, or the non-biological father being named as a guardian?
There's nothing that would preclude him from being named. The problem would be if he went to file and get that legal authorization where there's still an existing biological father, he wouldn't have any sort of priority. Because
Could
there's
the parties agree to a priority?
Perhaps. I guess I hadn't considered that. I hadn't considered that question.
Thank you.
I'm trying to decide where to go with this now. I just, I just want to say I felt like Justice Pullman's example was very fitting because it seemed like she was describing our situation, especially with regards to the two younger boys who have not had any meaningful relationship with their father.
Well, and those do seem to be, that does seem to be more fact-specific than categorical. I mean, I could certainly understand that it would be categorical if we had, if we said, well, whenever a step-parent wants to adopt, right, it's in the
Right.
child's best interest. But in a particular circumstance where the children haven't had any meaningful contact with the father, and have come to consider their stepfather as their father,
Right.
I'm not sure that's categorical because I don't think every step-parent relationship is like that.
Right. And I agree. I wouldn't consider it categorical either. The thing about this case is that it is, right, it was very dependent on these children, and I'm not standing here to say, judges, I think we should use this case to create some sweeping bright line rules, and we need to be creating new clarifications in the law. The fact of it is that the district court heard that evidence. Based on the evidence, it made these determinations. Those factual determinations are entitled to significant deference. And so we're asking this court to affirm the court's decision because that's what's in the best interest of these children. And in these circumstances, even the standard that father wants this court to consider of saying it was strictly necessary, in these circumstances, the district court determined that it was strictly necessary, that it was important for these children to have this level of permanence because of some of the specific and special concerns with them. And so our position is asking the court to affirm that because it's appropriate in this case.
If you were to identify the most important reasons and facts that make it strictly necessary for the adoption to go through, what are the most important reasons? Whether it specific factual findings or more general than that?
I think the duration of the absence of father from these children's lives. This isn't a year or two. This is at this point, it's over a decade that they have not had meaningful contact with their father. It's over a decade that, again, I keep referring to the youngest two, but because they're really the ones that are still in this age of minority and that this decision is really going to impact at this point, right, that they've known no one other than stepfather. Then we have the findings, the issues that the court determined with regards to their need for permanence and their susceptibility to being in that unstable position. And I think, as Justice Hagan has brought up, that is just, I think, a concern that's heightened by the fact that if something, right, again, were to happen to mom, which could happen to any of us, then it would create a huge situation where they would be stuck in a position.
How long was father incarcerated?
That's a good question. I believe it was from 2013, July 2013, he was incarcerated. And I think it was 22, May of 2023. Thank you, Ms. Adams.
So about 10 years.
That he was released. And as the district court examined, from the time in 22 when these restrictions, that I agree that the record is unclear because we never got any clarifying information on what those restrictions were. It was simply father's testimony regarding that. From 22 through the time when we had this trial, father's behavior and actions remained largely consistent the way that he acted before when he was supposedly under this restriction where he couldn't contact the children to the time when we had the trial. He didn't. And so those are the factors that I think are important and that the court should consider. So.
Thank you, Mr. Alstrom.
Thank you, Your Honors.
Ms. Adams?
Thank you, Your Honors. Just going backwards, this court has a lot of questions about legal limbo. The next case we have coming up, Ross v. Cracked. Mother actually gave guardianship to her parents, and then when father in that case got the children, full custody of the children in a divorce proceeding, the grandparents intervened, and the district court said, well, you don't have legal rights, so file a motion. And so they filed something, and the court then gave custody of the children legally to grandparents while the divorce case and all of this stuff was ongoing. So I think there are certainly avenues to maintain the status quo. We have no evidence in this record that if mother were to die tomorrow, that father would sweep in, take the kids, and go. There's no evidence of that. And there's a lot of avenues for the district courts to kind of work through this situation in a way that would not disrupt the children.
So in response to the Chief's question earlier, could the stepfather get guardianship now?
I looked for that question yesterday, Your Honor, because that was my same thought. I am not entirely sure. Certainly there could be some kind of agreement, like we see in the case that's coming up, between the parents and the step-parents that would say, hey, you get the kids. I think there could be a signed agreement. But I wasn't entirely sure of the guardianship piece. There is a statute that says that no time can you have more than two parents, so I'm not sure if that kind of works. Just really quickly, at no point did the court consider therapeutic reunification, and that is what father was asking for. Like, I'm just not going to come in here and really destroy what's happening. Let's work through therapists. I think therapeutic reunification would have been a great option to termination here. Mother and father filed their filed the petition to adopt in 2020, and in 2021, when mother was trying to get this going, what she said is father is scheduled to be released from prison in 2023. The reason she gave for wanting the adoption to go forward was because father was being released from prison. That's on page 81 of the record. It makes it feel that this is a termination not because father would harm the children, but because it would disrupt their current living situation. He was coming back into their world, whereas he was incarcerated before. That certainly isn't strictly necessary. And then just really briefly about the children's disabilities, there was not a ton of testimony at trial about the children's disabilities, but certainly there was testimony about what their daily lives look like. And mother works, and stepfather is the one who gets the children off to school and is with them after school. And this is what stepfather says. For the oldest, who has the most learning disabilities, he says that she needs help staying on task. That's it. That's on page 474 and 475. He's also taught her to make dinner. So she makes lasagna and spaghetti and meatloaf and macaroni and cheese. That's on page 476 to 477. But there's nothing in here that she can't handle disruptions. For the two youngest children, father, when he was talking about his daily activities with these two youngest children, all he says is they have a hard time keeping on track. That's on page 474 of the record. That's it. So it's not like we have children who are, I mean, I know that the spectrum is wide, so these are not children on the side of the spectrum that are nonverbal, who really need incredibly rigid routines to keep going. In fact, we have children who, in many ways, they've had some therapy and they've had some intervention, and they go to school and they interact at school, and they come home and they have it appears very normal kid lives. So there simply wasn't evidence on the record here that that they were in such a way where they could handle nothing coming into their lives that would be slightly different. Certainly, parent-child relationships, even with estranged parents, are complicated, and it's hard to predict whether that estranged parent coming back into their lives will be psychologically good or bad for the child. But here, we have no evidence about how the children would react. And absent that evidence, and absent any finding from the court about that, we simply can't terminate father's parental rights. And for these reasons, we ask that this court reverse. Thank you.
Thank you, Ms. Adams, Mr. Olson. We appreciate the arguments here today and the briefing as well. Really helps our process to have such quality advocates. Justice Nielsen, did you have any further questions?
I do not. Thank you.
Okay, well, thank you, and we will move on to the next case.